We deal with death in many forms every day of our lives. The death of a relationship, the death of a career or a job, the death of innocence, or the death of a loved one. But if we are willing, these encounters can help ready us for a dignified conclusion to our own life and teach us to face that inevitability with some grace. I believe it is our personal right and our responsibility to make end-of-life decisions for ourselves. And it is the responsibility of legislators to sort out the role of governments, doctors, and families in helping ensure our right to make such a fundamental and difficult decision as the right to die. This is a tricky topic, and I know some people may not even want to engage, but it's something that I have very, very strong feelings about, and I think it comes from my own personal experience watching a father die a long and slow death from cancer and a mother suffering from dementia, then Alzheimer's. So join us if you want to learn a little bit more about this topic. We're so pleased to have with us Helen Long. She's the CEO of Dying with Dignity. This is an organization that's dedicated to fixing some of the rules. Helen, thanks for being with us. And I think we're just going to do a mini background piece here just on the legislation, because there was a Supreme Court ruling in, I think, 2015, and that's where this whole discussion on MAID, medical assistance in dying, started. So can you just bring us up to date?
Yeah, so you're referring to the Carter case in 2015, which, yes, led to the legislation in 2016 that was introduced as Bill C-14 and became the medical assistance in dying legislation that we deal with today. So fast track to 2019 and the Truchon decision. So Jean Truchon and Nicole Gladue at the Quebec Superior Court arguing that their exclusion from access to MAID as a result of the death not reasonably foreseeable clause was discriminatory. And Justice Beaudoin in that case ruled that the current legislation does in fact violate both Section 7 and Section 15 of the Charter, the rights to life, liberty, and freedom, and that people with disabilities were in fact being discriminated against if they weren't near death. Because they couldn't access MAID. So the justice gave the government 6 months to put the legislation in place. And then, of course, COVID happened. So there's been 2 extensions. And currently, the bill is at second reading in the House. The current deadline is December 18th to try and get that legislation changed so it does, in fact, comply with the Constitution.
And it'll come over to the Senate again, where it was the last time the chair of your board, Jim Cowan, and I worked together. It was an interesting process in the Senate because people gathered not on party lines, but on how they viewed this issue and really tried to make some changes. There are 2 things with this new bill. So they've just called it a different number. It's now C7 as opposed to C14, if people hear us referencing that. So when the court in Quebec said, look, you can't discriminate, it was really this whole idea of you can access medical assistance in dying if your death is foreseeable. Something like a cancer diagnosis and the doctors have given you 18 months to live or 3 months to live, then you can do it. But in many other situations, you still can't. And the one, of course, that troubles me the most is the kind of the catch-22 Canadians diagnosed with dementia or Alzheimer's. You can't make a request in advance. Never mind the 90 days, we'll come back to that. But you can't say at this point in your life, look, I don't want to live like that. And when the following conditions have arrived in my reality, then I want to bring this to an end. Is that going to change?
Well, that's not going to change in this bill. So this bill, it addresses 2 things. First, it addresses Truchon, and it does specifically deal with the reasonably foreseeable clause by removing it and making it part of the safeguard process. The second thing it deals with is what we would call Audrey's amendment or advanced consent. So In the case of Audrey Parker, she was a Nova Scotia woman. I think many Canadians are familiar with her story. She had cancer and then developed a brain tumor. And Audrey's greatest wish was to spend one last Christmas with her family. Unfortunately, the law currently says that you must be able to give consent at the actual time of the procedure. And because of her condition, Audrey was very afraid that she would lose capacity and not be able to consent. So she ended up dying in November of 2018 instead of, a month or 2 months later, because she was afraid of losing consent.
So she had to bring her life to an end earlier.
Yes,
because
absolutely.
she wouldn't be able to give that consent.
Yeah. And we have, we hear this story all the time. Canadians, they're so afraid that they're going to end up in a situation where they can no longer consent. And yet they may continue to live in insufferable pain and continuing to, an intolerable situation. So they opt to end their lives early. The bill does provide for advance consent. So an individual in that situation, assuming they've been assessed and approved and they've actually set a date for their MAID procedure, if they lose capacity in the time between, the clinician will be able to go ahead with the procedure, and that waiver of final consent has been put in place.
But that, again, applies to diseases or issues like cancer.
Yeah, and you're absolutely right. Advance requests will not be addressed at all. It's our hope, and I think the government has spoken about this on numerous occasions, that when the 5-year parliamentary review that is required in the existing legislation begins, hopefully very soon, that is one of the topics that needs to be addressed and considered.
Two things on that. Just recently, we've seen that there's a logjam on the Justice Committee because there are so many issues that the government has brought forward in terms of Indigenous issues, just a whole lot of them. That there's no room to kind of get it on the agenda. And I guess from my own point of view, the last time we went through this, there were promises that the government would study these issues and take it from point A to point B. But they studied the issues and they really didn't come to any conclusions. They just had a discussion of the issues, but it didn't move the yardstick.
Yeah, that's true. I think, I think we continue to hope that there is a way to move forward. I think getting to that parliamentary review, it is a requirement. So, quite frankly, the government will need to figure out how to do it. Can we do it through perhaps a joint Senate House committee? Is there another way to maybe get there? And I think, yes, the government did some work, and certainly there was some academic work done. And even earlier this year, some consultation, a survey that over 300,000 Canadians participated in. But take all of that information, if it needs to be built on, build on it. But they have to find a way to have this discussion. It's a requirement of the legislation. And we know advance requests specifically, 85% of Canadians are supportive of advance requests. It's probably the number one thing that we get called about from Canadians who don't technically qualify today. And, by continuing to deny that, we're just not just demonstrating the compassion and the care for people that we should be. There has to be a way to get there.
This is what surprises me, because the Supreme Court in the first case basically was way ahead of the government. They were more lenient. They were more open to this idea. And the government came in and put more constraint on it. And then we see it again with public opinion. I mean, if there was any other issue that 85% of the public agreed on, you'd probably see some government running to the head of the parade.
Yeah, that's it is certainly overwhelming public support, I think, for that specifically, but a number of issues. And I think, Canada still is at the forefront or close to the forefront, which is great. I think it's also wonderful that we now have almost 5 years of experience. So we've got clinicians and Canadians who've been through this process, who can now speak to the experience that they've had in Canada. So all of that, I think, is helpful as we continue to try to move forward.
Just let me stay on this issue for a bit, because it does have to do, we've been told for years in this country that we should have a living will, that would make it easier for family members or loved ones to make a decision or to help us make a decision in our final days. There's the whole issue of power of attorney, which you have the right, when you are of sound mind, to hand over decision making to a lawyer or a third party. Why can't we translate that into a reality for this issue? Because we have it on finances and how families will be dealt with, distribution of property, animals, all sorts of things. It seems odd that we can't focus in on this.
Yeah, I mean, I hope when we get to the parliamentary review and the discussion, these are the things that we talk about. And I think it's going to be important to make sure that we have the right safeguards in place. But yes, I think you're right. There must be a better way to get there. One of the things that we really encourage people to do, and particularly through the pandemic, we've had a lot of calls about this, is what we call advanced care planning. So having the discussion with your family around what you would like to have at end of life. And we know that, that MAID can't be something that your family chooses, and nor should it be. It should be an individual's decision. But just having the discussion about what you would like to happen and what types of procedures you're open to or not open to, what your values are, what's important to you at the end in terms of your quality of life and your situation, so that in the event that you're not able to speak for yourself, the people that love you can speak for you and know what you would have asked for. So I think just, with the pandemic this year, that's really highlighted that need to make those other plans.
I want to ask you about a case that speaks to that, though, fairly directly. A Nova Scotia couple where the husband had asked for MAID. He had been rejected and asked again and was approved. And his wife literally took him to court and said he couldn't make this decision. In the end, he was allowed to. How does that sit as a precedent? Or was there anything in the activities or legal responses around this that either gives you hope or causes concern?
Well, I mean, it was certainly very concerning to us to see him have to suffer for additional months, quite frankly, and while, perhaps at risk of losing capacity. So that was certainly very, very concerning. And I think we felt, just the suffering that he had to continue to endure was quite tragic. I think it's wonderful that in the end he was able to access his right. And at the end of the day, I mean, this is a constitutional right that a Canadian has. And he followed the rules. He was assessed. He was declared eligible. They actually had multiple clinicians involved. And at the end of the day, he was eligible for MAID. He should have been allowed to move forward. I know there are people who felt badly for his wife, and I'm sure it's a difficult thing to go through. But that's why we encourage the conversation, because at the end of the day, it's his decision. He is the one who gets to control his end of life and decide how he wants it to look. And no one, no matter how much they care about you, no matter how close to you they are, no one else should be able to take that choice away from you. So we're pleased that he was eventually able to make that decision and access MAID. We are, very sorry that he had to endure so much extended suffering to do so.
And again, it comes back to that issue of advanced directives, because he was able to continue to express his will despite pain and suffering. Many are in a situation where they cannot continue to express that. So the decision implicitly is taken away from them.
Absolutely.
Let's talk about a couple of the other issues. I just want to come back. There was a small, not small, I think a significant change, I guess, in this version of the legislation on the 90-day waiting period. Just to explain where we're at on that.
Yeah. So for individuals so we talked about the fact that currently your death has to be reasonably foreseeable. And in the new legislation, that may not be a requirement. However, they want to make sure that there's a safeguard in place around that. So in the event that you're assessed and approved for MAID, but your death is not reasonably foreseeable, there is a 90-day waiting period between the first assessment and the provision of MAID, unless both assessors agree that the individual's loss of capacity is imminent. So, it does make sense to have a safeguard, I think. I think the provision that capacity can impact moving that timeline is good. I think there should perhaps be some consideration given to maybe a shorter timeline. We know that Canadians who have opted to choose MAID spend a lot of time thinking about it before they make the decision. So
you don't need another 90 days.
Exactly. And again, it just extends that suffering, right? They already know what they want. In many cases, although the official assessment may not have occurred, they're already dealing with a clinician. They've already got they've looked at their options, they've explored treatments and made those types of decisions. So 90 days may be longer than is necessary in all cases. And there should be some flexibility, I think, around that time frame.
And how do you want that purposely vague instead of saying 30 days as opposed to 90 days or 10 days as opposed to 90 days? Do you want people to be able to make that judgment, or is it better if there's a specific timeline?
Well, I think we always feel fairly strongly that clinicians are those best positioned to make those decisions and to know, have they been involved? How long have they been involved? How long has the person been expressing the request? So really, I think shorter than 90 days is probably ideal. Flexibility from clinicians is definitely something that should be included.
You mentioned the phrase assessor, and I think there is some flexibility. You don't have to have the world's greatest expert in disease X. It can be somebody who's familiar with the case, but you need two people. Is that correct?
Yeah, two people, and depending on the province, it can be a physician or it could be a nurse practitioner. And again, in the case of a death not reasonably foreseeable case, one of the safeguards is that one of the individuals must have some expertise in the condition. So not, as you say, that they're necessarily a specialist, but they have to have some experience and expertise in dealing with that particular condition.
So somebody dealing in palliative care or a personal home care worker, something like that.
Yeah, probably more along the lines of someone who's had experience in a specific condition. Okay. So, like a specific type of arthritis or, whether it's multiple sclerosis or a disease state.
So again, this is a question, and it's partly because I come from a small town in Saskatchewan, which these things are great if you live in downtown Toronto or downtown Vancouver. You've got your choice of clinicians. If you've got a doctor who fundamentally disagrees with the idea of MAID, you can go somewhere else. You can seek other help. If you live in a small town, and there are lots of rural parts across this country, you don't have a lot of options.
No, that's true. One thing that the pandemic has brought us that has been helpful is, I think, a greater appreciation and acceptance of telehealth. So looking at virtual assessments in many provinces, that is something that is allowed. And I think it serves those individuals who live in remote or underserviced communities. That really does help to support them in this process.
And that's acceptable?
In some provinces, not in all provinces. That's something we'd certainly like to see expanded.
So does that need to be part of this legislation?
No, that becomes part of the, as you know, health is regulated provincially. So that would become part of the provincial either regulation or perhaps at the college. It varies from province to province.
I want to raise a couple of the other concerns that people have, and the one issue when it comes to mental health is in some ways related to the issue of Alzheimer's and dementia, because it might be considered a mental illness rather than a physical illness or some combination of the both. But there are still grave concerns and restrictions on people who seek MAID, medical assistance in dying, because of mental health issues. They may be schizophrenic. They may have massive depression. They may have gone through all kinds of forms of treatment and nothing's working. So where do those folks stand?
Well, mental illness is specifically excluded from the new bill. I think this is obviously a very complicated issue, and I think there's some differing opinions. I'm not a clinician, but I think differing opinions in terms of what a mental illness is that will certainly impact accessibility for those Canadians who are in that situation. Again, when we look at the parliamentary review, one of the areas that was specifically identified and even talked about last time was the fact that mental illness is challenging and we need to take the time to get it right, but we do need to take the time and actually get it right. So there has to be an opportunity. We shouldn't be discriminating against those with a mental illness just because that's what they have. They should have the same right. There's nothing, we have no reason to think that their mental suffering is any less than the physical suffering that other Canadians are going through.
We all know people like that.
Yeah, we
do.
Their
pain is real.
Yeah, it's very real. And I think, we hear stories. If you visit our website, there's lots of blogs from people who are in those positions. So I think it's critical when they get to the parliamentary review, and the sooner the better, quite frankly, this is one of the three things that we really think they need to address.
And then the issue of minors. And I know if you take a look kind of around the world, the question of minors, it's defined by age in many cases. In some countries as young as 12, in other countries as old as 18. So somewhere in that range. But the general response is, look, kids shouldn't be making these decisions, but we're not really always talking about chronological age.
No, we're not. We're talking about, I think, their capacity to make these decisions. And certainly when you look at other medical decisions, which, treatments that could be life ending or life continuing. Right. I don't know how you want to look at that, but mature minors are already making these decisions. And so there has to be a way for them to be considered, whether it's age or some combination of age and capacity. It's certainly something that I think the medical system is more than capable of helping to define.
So how do we, as you say, if there's a minor who is receiving treatment for cancer, they can at a certain point decide that they don't want to continue that treatment and say, Mom and Dad, I'm stopping this. So it's just that next step, is it?
Well, I think it's a similar, in their minds, it can be a similar decision. I think the decision to stop treatment is one decision, but then the resulting condition is eventually, unbearable pain and unbearable suffering and, having to take drugs to control the pain and then not being able to interact. Like that person should, regardless of their age, if they can make the decision to end their treatment, they should be able to make the decision to choose the end of life that is right for them.
And is there any legal precedent in this country at all, or are you looking to other countries to help build a case?
Yeah, there's obviously no legal precedent in Canada right now that I'm aware of. We would certainly look at what's going on in other countries, and as you note, it's a fairly wide range. But I think we will also look to the decisions around other health treatments and medical treatments that exist, and certainly to the expertise of those clinicians that work with mature minors.
So the process is now that the bill is in the House of Commons and it will come to the Senate. So we always have this discussion amongst ourselves, particularly as senators, because we are at the last stop, the sober second thought before something becomes a bill. Do you take something instead of nothing? There have been some things in this new legislation that will come, that's been put forward in the House, some small improvements. Do you say, okay, let's take an inch and still work on the mile, or do you say, let's get it right and don't pass legislation?
I think you can. I think this bill, because really this bill it's not that huge. It's a in terms of bills, it's a fairly comprehensive and tight bill, but also quite brief. And it deals with at the end of the day, two core issues. The one which is required to be dealt with because it's unconstitutional from the Truchon decision. And the second being Audrey's amendment, which I think there was a lot of discussion around last time. And I don't think that there can be that much, it seems like such a small thing to ask that someone can waive that final consent in order not to end their life earlier than they would like to. So, yes, I think we take this bill because we know that parliamentary review is mandated by the legislation. It has to happen. So we take this bill and then we take more legislation, more discussion, more improvements that help Canadians to be supported, to show them compassion, to ensure that they're able to access their constitutional right in a way that they want to do.
So take something to look at this as a step-by-step process, and perhaps there'll be other decisions in the courts along the way that will have the impact that the Quebec Superior Courts had, which they've said, you've got to go back and fix it.
Yeah, that's always a possibility.
Yeah. And I mean, the issue, I guess, we've got if they don't act is that you have two different levels of access in Quebec and the rest of Canada, and then that becomes another issue.
Yeah, and that's something that absolutely becomes an issue. We've already, we know there are six now individuals in Quebec who have been able to move ahead and others waiting. We're certainly hearing from Canadians in other provinces who are, well, how can I do that? And there isn't anything right now, but I think the longer this goes on, the more chance that there will be someone who says, okay, what's the next step? How do I ensure that in whatever province I'm in, Ontario or BC or Nova Scotia, how do I get what you can access in Quebec? Because it should be the same for all Canadians.
Instead of people trying to fly to Switzerland or someplace to deal with this, if they can even possibly afford it. Two other points before we begin to wrap this up. The assurances that need to be there for the disabled community or the I'm not sure that's the right word anymore, but people who are afraid that if they are not physically or mentally completely able, that they are vulnerable to people saying, you're a drain on society, you cost too much. There's real, genuine fear there.
Yeah, I think there is fear. And I think, certainly nothing about medical assistance in dying negates the important need for appropriate services and supports. At the same time, I don't think that we can discriminate against an entire group because of fear that they may not have a rational and legitimate desire to end their life. So I think continuing to put emphasis on supports and services, ensuring clinicians are evaluating the situation and making sure that the individual is the one who's making the request and they're making it for the right reasons. I think those are critically important things that need to happen. But we can't out of fear that we're not doing the right thing, discriminate against that group. People may very well have a legitimate desire to end their life. Their suffering may be intolerable for them. And at the end of the day, that should still be their decision.
The other issue that I think is important, and we all see it, and perhaps COVID has shone a particular light on it, but the question of palliative care, or even care for the aging, as we've seen, it's, to put it in the kindest possible terms, faulty at best. We've had people dying because of, yes, the virus, but also just because of lack of care.
Yeah, it's been, I would go so far as to say horrifying, terrible, unexcusable. Certainly, again, palliative care is a critical piece of the healthcare system. And I think many Canadians access it, and absolutely palliative hospice care should be available to any Canadian who wants to access. We know that individuals who choose MAID, 82% of them do access palliative care. These are all choices at end of life, and there are no right or wrong answers. It's about what an individual wants, but the individual should be able to make that choice. And in order for that to happen, all of those resources need to be in place. So certainly, yeah, I agree. The pandemic has shone a light on this. The government at all levels, I think, has committed to improvements, and it would be wonderful to see those improvements happen.
Are you satisfied that there are enough practitioners in this country who are open to a discussion about MAID, that people really from coast to coast to coast are able to access advice at the very least, and to access to MAID itself?
There's certainly a strong cohort of individuals who are MAID assessors and providers. There are areas we know where, I would call them underserviced areas, much as there are in other areas of healthcare. So I do think there is a large group of clinicians who are committed to and prepared to continue to assess and provide MAID. And we would hope that as education and information grows and expands, and Canadians are continuing to talk about their journey to MAID, that group will continue to grow.
What do you say when I know you have a very extensive website, and we'll post that too so that people can take a look. You've got advice for people that want to create a living will or an advance directive of some kind. You've got suggestions for how they might be able to reach their members of parliament or write a letter to the prime minister. What's your single piece of advice to people who care about this and think they may want to access this at some point in their life for themselves, or probably more likely for a loved one that they want to help?
Yeah, I think for any individual who's looking to access medical assistance in dying, I think that the critical thing is to have that conversation with your family and to talk to your clinician. There's in every province, there's a slightly different setup. There's care coordination centers, and many of the local health community centers will help. Certainly you can reach out to us to get pointed in the right direction. But having that conversation with your clinician and your family is probably the most important starting point.
And do that at an early point.
Yeah, do it early and do it often, because, as you go through life, things change, and the conversation you might have at 40 or 50 or 60 is not necessarily the same as the one you might have at 70 or 80. So the more we talk about it, the more we normalize the fact that death will happen. How do you want it to happen? And the more we do that, the better and the easier it will become for people.
When we've carved out a life for ourselves, a good life, and we've worked hard and we've done our best and we've raised our families and done all that, it just seems there should be no reason why that kind of dignified life needs to meet an undignified end.
Yeah, I think you're correct. You have a good life. You should have the ability to choose a good death.
Helen, thanks so much for talking with us today. I really appreciate it.
Oh, well, thank you for having me, Senator. I appreciate it.
Helen Long, she's the CEO of Dying with Dignity, and do go to their website if you're interested in this. There's a lot of very good information. We'll talk again when we see the process unfold.
Thank you. I'll look forward to that.
Thanks. Given our discussion today, it reminds me of the words of Charles Dickens, who once wrote that what is meant by knowledge of the world is simply an acquaintance with the infirmities of man. In other words, to be truly knowledgeable, we must recognize human frailty, the human condition. Some very wise words as we begin to deal with this issue in the Senate and in the House of Commons and across this country.